Okay. Hi, everyone. Thank you all for joining us for today's presentation. My name is Anna. I'm a social worker here with Legal Aid. With us today, we have Corey Frost, who is a staff attorney in the Winston-Salem office who works on domestic violence cases with Legal Aid. If you're unfamiliar with this format of this event, Corey is going to review a brief PowerPoint presentation. At the end of the presentation, we'll have a question and answer session. Please remember that this is a public forum and we are also not representing you at this time. Corey will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot give any legal advice specific to your individual situation. But with all that being said, I'll pass it on to Corey.
Thank you, Anna. Good afternoon, everybody. I'm Corey Frost. Like she said, I am a staff attorney in the Winston-Salem office at Legal Aid. I just noticed that this slide and the next slide say managing attorney, so I apologize for not having updated that. So I'm going to be walking us through a PowerPoint, and then we'll be happy to answer any general questions that folks have at the end. So who is Legal Aid? We are a statewide nonprofit law firm that provides free civil legal services to low-income people because our mission is to ensure equal access to justice. And what kinds of areas do we provide legal assistance with? These areas right here. We cover housing, employment, education. In the field of domestic violence, we generally assist folks with getting domestic violence protective orders, which is a type of restraining order, and several of these other areas that are listed here. If you find that you have other legal questions about some of those other areas at the end of this presentation and you're interested in applying for our help, you can either call us at the number there, or you can go on our website and apply through our website to see if Legal Aid is able to help you. So like Anna said, an important thing to remember is that in this presentation, we are giving you general information about how to go about filing for a simple divorce. We're not able to give you specific answers to specific questions about your case. And this presentation is recorded as well. So I'm not here acting as your attorney in your divorce case. I'm just an attorney who has some knowledge about filing for simple divorce, giving you some information about that. So keep in mind when you post questions in the chat or in the question and answer function, we can't guarantee you any confidentiality since this is open to the public. So just keep that in mind. All right, so what are we going to be covering today? So first, we're going to talk about is filing for a simple divorce the right thing for you right now? Is this what you actually need to file for? Then we'll talk about what kinds of information you're going to need in order to start that process, what kinds of forms you'll need to fill out, and how you can complete those forms. And then we'll briefly talk about what it's like when you go to court and get the judge to actually grant you your divorce decree. So first, is a simple divorce right for you? Is this what you actually want and need right now? So what does it take to qualify for a simple divorce in North Carolina? There are essentially two requirements. First, either you or your spouse need to have lived in North Carolina for at least 6 months by the time you go to court to file for the simple divorce. So it doesn't have to be you, but if it's not you, it needs to be your spouse or vice versa. A lot of questions, a lot of folks have questions about, well, what if I got divorced, or I'm sorry, what if I got married in another state? That's totally fine. You don't have to go back to that state to get divorced. If you got married in Tennessee or Virginia or California and you want a divorce, you can file for a divorce here in North Carolina, as long as you've lived here for at least 6 months or your spouse has lived here for at least 6 months by the time that you file. If not, you need to wait until you've hit that 6-month mark. The other requirement is that You and your spouse need to have been living separate and apart for 1 full year before you file at the clerk's office for a simple divorce. It needs to be 1 continuous year, and the separate and apart means it needs to be in separate residences. You can't live in the basement of the marital home, or move down to the basement, or move up to a separate part of the house. It actually needs to be separate addresses, separate residences. And if you and your spouse 6 months into your separation, get back together to try again briefly, and then realize you made a mistake, and then go back to living separately, that starts the 1-year clock over again, unfortunately. So it does need to be 1 full year. Aside from those 2 requirements, there's nothing else that you need to do in order to be eligible for a simple divorce. There are some other things that you'll want to consider before filing for a simple divorce. Filing for a simple divorce. So one thing is that once you get divorced, that will forever cut off your rights to seek financial assistance from your spouse, or seek an equitable distribution of marital assets or property. So if there's any chance that you want to seek post-separation support or alimony, or have the court divide up your marital assets equitably, then you will want to consult with a lawyer. You will not want to go ahead and file for a simple divorce, because once the judge enters that divorce decree, you lose forever your rights to seek those types of claims. And that's not something we're going to be covering in the presentation today, and I won't be able to answer questions about seeking alimony or equitable distribution of property. One thing, though, that you should also remember is that if you and your spouse have children, and you either have a custody order and/or a child support order, or you intend to file for custody or child support, that filing for a simple divorce will not affect your rights to file for custody, or your spouse's rights to file for custody against you. And the same thing goes for child support. Those are treated separately, and you can proceed with a simple divorce. So what kinds of information will you need before you file for a simple divorce? So the information that you'll need about yourself is everybody knows their full legal name, I'm assuming, and your current address. If you can track down your marriage license, I recommend that you find it, because you will need to know the date that you got married. You would be surprised the number of people that don't remember the date, or have trouble remembering the date that they got married. So having your marriage license handy will solve that problem. You'll need to have your children's full names and birth dates. That's only if you share children with your spouse. If you have children from a prior marriage, you don't need to worry about that. Or if your spouse has children from a prior marriage or relationship, you don't need to worry about that. Only if you share children with your spouse. And then you're going to need to decide where you're going to file for divorce. You don't need to file for divorce in the county where you got married. If you got married in North Carolina in Mecklenburg County, you do not have to file for divorce in Mecklenburg County if you no longer live there. Most of the time, it makes the most sense for you to file for divorce in the county that you're currently living. So that's where I recommend that you think about filing for simple divorce. And you'll need to know where the clerk of court is in the county. 99% of the time, the clerk of court is got an office within the courthouse. So about your spouse, you'll need to know their full legal name. You will need to have their current address, or at the very least, know where they can be located for the purposes of getting them served. So that could be a work address if you know where they're working. And I'll go over that more in a few minutes. And then you'll also need to know whether what your spouse's military status is, if they're active, inactive, or if they've never served. And there is a website that you can use to confirm that if you're not sure, that I'll go over in a little bit. So once you have that information, also you'll want to make sure that you have a way to print out some of the forms that we're going to be talking about today, or know where you can get things printed out, whether it's at a UPS store, at your local library. You will need to use a notary. Several of the documents that we're going to be talking about today need to be signed in the presence of a notary and notarized. Notaries, most banks have a notary on staff. If you want to go to a bank, most funeral homes have notaries, and very often UPS or FedEx stores will have a notary on staff, and for a nominal fee, they'll notarize things. You can also try DMV offices. One thing that's very important is most of the time, the clerk's office does not have a notary on staff, and even if they do, they are not able or willing to notarize paperwork. So the point is, you'll need to find a notary before you go down to court to file your paperwork. And some of the documents you'll need to send through the mail, so it's a good idea to know where your nearest post office is. So there's two different ways that you can file in North Carolina. One is what we used to do about a year ago. We would walk folks through individually each of the forms that you would fill out. In order to go through this process, there is a list of forms that we'll give you in another slide in just a second, that you can download one by one from the NC Courts website. And you can fill them in either on the computer if you can find a fillable PDF, or you can fill them in by hand if you prefer, and then take them down to the clerk's office to file. But we've started recommending that folks use this new system that they launched within the last year called the North Carolina Guide and File System. I will, in just a minute, show you what that system looks like. You can access it from the NC Courts website, and it will ask you a series of questions that you'll answer. You'll type in the information that they ask for, and the system will fill in the forms that you need to fill out automatically. And then at the very end, it will give the forms to you filled in so that you can print them out. You can download them and print them either on your home computer if you have a printer at home, or you can take them, like I said, to a library or to a UPS store. And then, of course, once you've printed them out, signed them in the presence of a notary, you can take them down to the clerk's office to get them filed. So the NC Guide and File System is what we'll be showing you today. All right, I just talked to you about what this system looks like. So I am going to jump out of this PowerPoint and walk you through. Let me share my internet browser. All right. So when you go to the NC Courts website, it's nccourts.gov. This is the landing page. This is what it looks like. So when you get here, if you want to access the NC Guide and File System, you'll come up here to the drop-down menu under Services, down here to Guide and File. It will take you to this page. Whichever county you decide that you want to file in. Again, most of the time it'll be in the county where you live. You'll select that county from the drop-down menu. I'll just go ahead and select Alamance just because it's the first one. So then it'll take you to this page. You will scroll down here to eCourts Guide and File, Start a Filing. So I'll click that. And over here is a list of all the different things that you can do through the Guide and File System. If you live in certain counties, I think Wake County, maybe Johnston County, and I think Mecklenburg County, not only can you fill out the documents on the guide through the Guide and File System, you can actually e-file, which means that you can submit them online and they'll go to the clerk's office. But if you don't live in Wake County, Johnston County, Mecklenburg, and there's one other one I can't think of at the moment, then you will have to print them out and bring them in person. So once you get to this page, you are filing for absolute divorce. Absolute divorce is another way of saying simple divorce. So you'll click on that. All right. So then we'll click Start. All right. So this is more or less what the system looks like. It'll ask you a series of questions, and you'll have to, once you're finished filling in the questions, answering the questions, you'll click Start or Next, and it'll walk you through step by step. So I wanted to show you the first couple of screens just so that you all are familiar with what it looks like and are comfortable with how it works. All right. Well, in the interest of time, this is what the guide and file system looks like. I'm going to jump back to the presentation. All right. So if you are not comfortable using the guide and file system, or as we just saw, if the system is inordinately slow and you don't have the patience, usually it's not that slow, but if it happens to be not working or the site is down and you want to walk through the individual forms, and fill them out yourself, you can find them all at the NC Court's website. We've provided you the link below. And on this slide, we've given you a list of all of the forms that you might need, that you will need. Some of them are required, others are optional. These are the forms at a minimum that you'll need to fill out in order to start this process. In the packet that you can find on Legal Aid's website. If you go to our website to the Listen and Learn and Clinic section, you can download a copy. You can download a packet for simple divorce, and in that packet is a template for a complaint that you can fill out. That is, the complaint is basically you're telling the court what it is that you're asking for, what type of civil action this is. This is an action for divorce, and this is what I'm asking for. So you can use that form that we've provided at our website. The other forms you will need to find on the NC Court's website here. The civil summons, which is required anytime you file a civil a lawsuit against somebody. The civil summons notifies somebody that someone has filed a civil action against them, and that they have a period of time to file a response or an answer if they wish to do so. An answer in a divorce case is not required. For a simple divorce, it's not required. The domestic civil action cover sheet, that sheet is for the clerk's office, that notifies the clerk's office what type of filing this is. So on that form, you'll see there's a box that you check for simple divorce or absolute divorce, I think is what it says on the form. The Service Members Civil Relief Act affidavit. This is a form in addition to the civil summons and the complaint that will need to be signed in the presence of a notary. This is where you indicate whether what your spouse's military status is. And if you aren't sure what their military status is, you can go to the Service Members Civil Relief Act website and run a search on using their name and date of birth, I believe. And it will tell you what their military status is. You can print that out and append that to the document. And basically you sign the document saying, I've run a search using this website and confirm that they are not in the military. Why is that important? Well, because the Service Members Civil Relief Act provides some additional rights and protections to active duty service members. And the court cannot proceed unless it has confirmation that the person that you're suing is not an active duty service member. In North Carolina, there is a filing fee for absolute divorce. I want to say it's $75. And then there's an additional $30 fee if you want the sheriff's office to serve the paperwork on somebody. And for a lot of folks, a lot of the people that we serve at Legal Aid, those kinds of filing fees are a financial burden. And if that is the case for you, you may want to consider filing these two documents. So the first, the petition to proceed as an indigent. This is a document that this is where you will indicate whether you receive any type of government assistance, whether it's SNAP benefits, Social Security disability, those types of things. If you don't receive any of those types of benefits, then you may want to use the affidavit of indigency, which is where you will provide a rundown of your household income and expenses. And then the clerk's office will use those documents to determine whether you're eligible to have the fees waived. If it is not a financial burden for you, and you can pay the filing fee, then I wouldn't worry about filing those two optional documents. If you're over income, the clerk's office isn't going to waive the fees, but if you do fall below a certain threshold, they'll waive those fees. You can find those forms over here. We provided a screenshot of the NC Courts website. You'll just type in the form numbers over here to the side, AOC CV 100, to get a copy of the civil summons, where you can download it and fill it out. This is a good point. These are the forms that are required in every county, all 100 counties in North Carolina. However, some counties have an additional form or two that they require that you complete just for their own record keeping. And so before you go down to the clerk's office, after having filled out these forms, signed in the presence of a notary, the ones that require you to do so, I recommend that you call the clerk's office and just verify, tell them that you want to file for a simple divorce. Tell them that you've got your complaint, your civil summons, your domestic civil action cover sheet, and your Service Members Civil Relief Act affidavit, and ask them if there's anything else that they require that you complete, any other forms that they require before you go down there, because it may be a form that they require is notarized and you won't be able to file it there. You'll have to leave and come back. So save yourself the time and the headache and call the clerk's office in advance. So you have decided that a simple divorce is right for you. You meet the requirements. You've got all your information. You found the forms and filled them out. You've gotten them notarized. Now you're ready to go down to the clerk's office to file the paperwork. So what are you going to need before you go down to the clerk's office? You're going to need to make some copies. So once you complete the forms, you'll need to make 3 copies each of the complaint, domestic civil action cover sheet, and the civil summons. 3 copies as well of the Service Member Civil Relief Act affidavit. And then some counties require, or all counties require, that you have 2 copies of the petition to proceed as an indigent. And I believe this is an original plus 2 copies when it says 3 copies. One will be, the ones that are 3 copies, one will be for the court file, the original, one will be for you, and one will be for serving on the other party, your spouse in this case. One thing I do want to note is that in some counties, if you use the sheriff's office to serve the paperwork on your spouse, some sheriff's offices require that the civil summons be printed on yellow paper, that the 2 copies be printed on yellow paper. So that's another thing where you're going to want to call the clerk's office in your county just to double check if there's any kind of requirement like that. All right. So then we talked about this already. Make sure that before you sign any of these documents, you check to be sure it's not one that requires that's required to be notarized. And it'll be obvious. There'll be a space right below your signature or right next to your signature where a notary would fill it out. It'll say sworn and subscribed to before me, and a space for a notary to sign. If you see that on the form, then make sure that you not sign it. Take it to a notary and sign it in front of a notary. Okay. Once you've got all the documents you need, they're notarized, you'll go down to the clerk of court in the county where you're going to file. You will tell the clerk's office, I'm here to file for a simple divorce, and I've gotten my paperwork right here. On the paperwork, there'll be a spot up at the top on some of the forms where it says file number. You will not complete that. The clerk will fill that in for you. And the clerk will take the paperwork from you. He or she will file stamp all the copies that you bring in. They'll assign your case a file number, and they will keep an original for the court file, and they will give copies back to you. In most counties, the clerk's office, or if you decide that you want to serve the documents using the sheriff's office, and I'll go over this in more detail, you will have to take the paperwork yourself to the sheriff's office. And so you should get all the copies back from the clerk once everything's file stamped. But there may be a few counties where the clerk's office takes care of routing the documents to the sheriff's office, but that is not the norm. So service of process. Service of process is a required and fundamental step anytime you file a lawsuit against somebody. And filing for a divorce is considered filing a lawsuit. It's a civil action. And service of process is basically formally giving the person that you're suing, in this case, your spouse, notice that you are seeking a simple divorce. And you are required to go through this step before the court can issue you your divorce decree. If you go to court and you cannot provide proof that the defendant has been formally served, the judge is going to continue your case to a later court date to give you additional time to serve the defendant, and your case won't be able to move forward until that happens. There are three primary ways that service of process is accomplished or can be accomplished here in North Carolina. I'll be going over each one of these. There's actually a fourth method that I'll touch on briefly that is a good option if you and your spouse have separated on amicable terms, and your spouse is aware that you're filing for a simple divorce and wants to go through with the divorce as well. That fourth option that I'll talk about may be a good option for you. But for most of you, you'll use one of these three methods. Service by sheriff, which is by far the most common method, service by certified mail, which is really a good option if you know the address where your spouse lives. And then a less common option that you need to get permission for, which is called service by publication. And what specifically do you need to serve on your spouse? They need to get, at a minimum, they need to get a copy of the complaint and one civil summons in order to be properly served. And then there needs to be proof in the court file that the defendant was served. And I'll talk to you about how you make sure that there's proof in the court file that your spouse was served. So service by sheriff. Like I said, sometimes you can do this at the clerk's office. Most of the time, however, you'll have to go to the sheriff's department and ask for civil process. The sheriff's office, most of the time, their office is right there in the courthouse, or it's just down the street in the jail. So you'll need to go to one of those two locations in order to do this. You will bring them one copy of the complaint and 2 copies of the civil summons, because those are the 2 documents that your spouse will need in order for you to serve them, and tell them, I'm here to ask for civil process. They generally charge, or the fee is $30 to serve somebody via sheriff's office, unless you were able to get your filing fee waived. And the clerk's office, if they waive your fees, they'll indicate that your fees were waived on the paperwork, so that when you go to the sheriff's office to have them serve your spouse, they'll see on the paperwork that your fees were waived, and they won't ask you for the $30 fee. So what does the sheriff's office do? One of the deputies that's assigned to serve civil paperwork will take the paperwork that you give them and the information that you provide them about your spouse's whereabouts. 9 times out of 10, that will be their home address, or if you don't know their home address, their work address. And they will go to your spouse's home and physically hand the paperwork to your spouse. And then on that second copy of the civil summons, they will note the date and time that they served your spouse, and they will take care of sending that back to the clerk of court's office. And if you are not sure whether the sheriff's office has succeeded in serving your spouse, you can always call them and ask. And you will need to know the date that your spouse was served. So I recommend calling the sheriff's office. You can also, if a period of time has passed and if you've had trouble getting a hold of the sheriff's office, you can check in with the clerk's office to see if they've received the summons back from the sheriff's office. The more information you can provide to the sheriff's office about your spouse's whereabouts, the more likely it is they'll be able to serve your spouse. And by that, I mean, if you know, for example, that your spouse lives at such and such an address, but you also know that your spouse works, from 8 o'clock in the morning until 5 o'clock in the afternoon, you may want to let the sheriff's office know that. Here's their home address, but they also work during the day, so the best time to serve them would be after 5 o'clock in the afternoon or evening. The sheriff's office will not act as a detective. They will not try and track down your spouse. They will only go to the addresses that you provide them, whether it be a work address or a home address. And like I said, you'll need to know the date that the defendant was served. So if you don't want to use the sheriff's office for whatever reason, another option could be certified mail. What you do is you'll take 1 copy of the complaint, 1 copy of the civil summons, put them in an envelope and take them down to the post office. If you have never sent something via certified mail and you're not sure how to do so, you can either ask the staff at the post office to help you fill out the paperwork. There's a little square piece of paper that's got some green on it that you'll need to fill out. And then there's a larger green rectangular card that you'll need to fill out as well with your spouse's name and address. The fee is less than $10 for just a small envelope. And on the paperwork, you will need to note, or you'll need to check the box for return receipt requested. Let me see, return receipt requested, and I'm blanking on it. Give me one moment. Restricted delivery. It's been a while since I've sent something via certified mail. So you'll check the box for return receipt requested, restricted delivery. What that means is you're going to get the green card back in the mail once the post office has delivered the mail successfully to your spouse. And restricted delivery basically means they will not give the envelope to your spouse. They can only give the envelope to your spouse. They won't give it to anybody else who happens to be at that address if your spouse lives with somebody else, because you want to make sure that the paperwork gets to your spouse, not somebody else. So when you get the green card back in the mail, you're going to want to keep that for your records, because that indicates, number one, that's proof that your spouse received it. And number two, it'll have the date on it that your spouse received the paperwork. So keep that card with you. And that, in essence, is service by certified mail. In addition to service by certified mail, or in addition to sending the paperwork via certified mail and getting the green card back in the mail, you have to take this second step, which is filling out this affidavit of return of service by certified mail. Where do you find this form that's here on the left? This form can be found in the packet, the simple divorce packet that's available on our website that I was telling you about earlier. So feel free to use this form, just fill it out, attesting that you sent the paperwork, the complaint, and the civil summons to your spouse in the mail, and then you will sign this in the presence of a notary and get it notarized. Then once you've gotten it notarized, you will take this affidavit along with the green card down to the clerk's office and you'll file it. You'll get it filed and they'll put it in the court file so that when you come back to court for your divorce hearing, the judge will have proof that you served your spouse. And so this is the this other option that I was telling you about. This is not going to be a good option for everyone. This method called acceptance of service. Basically, if you and your spouse have separated amicably, things are not acrimonious, both you and your spouse want to get a divorce, get the divorce finalized, and your spouse is aware that you're filing for a divorce, you may want to use this acceptance of service method. Basically, you will actually take a copy of the complaint and the summons to your spouse. They have to be willing to accept the paperwork from you. And then once you've done that, they will have to sign this acceptance of service form in the presence of a notary and give this back to you so that you can then take it to the clerk's office and get it filed. This method, again, only going to work in certain circumstances where you and your spouse are on amicable terms. I do not recommend using this if you and your spouse haven't talked for a while, or if your spouse is not aware that you are filing for a simple divorce. I would highly encourage you to use one of the two methods we just talked about, either using the sheriff's office or certified mail. In North Carolina, you cannot take a copy of the paperwork, give it to your spouse, and then come back to court and say, well, Your Honor, I served my spouse. I gave her a copy of it, 3 weeks ago. That's not going to work. If you want to be the one that gives the paperwork to your spouse and you feel comfortable doing so, then you need to use this acceptance of service method and have them fill out this form, get it notarized, and bring it back. So what if you have lost track of your spouse through the years? You have no idea where they're living, and you cannot track them down. You don't know an address. So service by certified mail and by sheriff or by acceptance of service really isn't an option. What do you do in that circumstance? There's this last method called service by publication. It is time-consuming and expensive, and you have to get permission from the court to do it. And so I do not recommend it if you can avoid doing so. Like the slide says, it is a means of last resort. Only in those cases where you have exhausted all of your means of finding your spouse's whereabouts, their address, will the court allow you to use this method called service by publication. And in order for the court to give you permission to use it, you're going to need to provide proof to the court, or you're going to need to provide some testimony to the court about what attempts you have made to track down your spouse. If you have attempted to serve them at the last address that you know of for your spouse, and the sheriff's office has come back and said, hey, we went to that address and the person doesn't live there anymore, there's someone new living there. If you've tried sending it to them via certified mail and it came back saying person no longer lives there, you've searched on the internet, you've reached out to family and friends, no one knows where your spouse lives. Maybe if you have the means, you've used a private investigator, and you absolutely have no idea where your spouse is. At that point, the court may give you permission to use service by publication. And what is service by publication? Basically, what it means is, I have never used service by publication myself, so this is something I recommend you checking with the clerk's office. But basically, you need to run a notice in the paper of record in the the last known address where your spouse lived. For example, if the last known address for your spouse is in Fayetteville, then service by publication means you're going to need to run a notice in the paper saying that you have filed a simple divorce against them with the file number in such and such a county. And you've got to run that ad in the paper of record for Fayetteville in this case for, I think it's like 3 weeks or something like that, 3 or 4 weeks. I haven't looked at the rules in a while. And so it can be expensive because you have to pay for the ad unless the newspaper is willing to donate it to you or waive the expense. Most of them are not willing to do that. And then once you've done that and can provide proof to the court that you've done that, then the court will, at that point can say, okay, we have deemed your spouse to have been served, so to speak, because you've given them notice in the only way that you can, since you don't know their whereabouts. I would, like I said, I would highly recommend you use any methods at your disposal to try to find your spouse, because service by publication really is a hassle and it really can get expensive. So once your spouse is served, then you can talk about getting your divorce entered, entry of judgment. So there are basically 2 methods of getting your divorce entered. Not all methods are available in all counties. Some counties allow you to do what's called an uncontested testimonial divorce before, judgment of absolute divorce before the clerk, which is where you submit all your paperwork to the judge, the clerk of court, you provide proof that you've served your spouse, and then the clerk can go ahead and issue you a decree of absolute divorce. That's not available in every county, so call the clerk's office to see if that's something that is offered. What is more common, I would say, is the second one that's listed, uncontested testimonial divorce before the judge, or really testimonial divorce before the judge, whether it's contested or not. So we'll go over what these look like. Again, the procedure may vary from county to county. Always recommend contacting the clerk of court to see if they have any specific rules or forms that you need to complete. We talked about that. So a testimonial divorce hearing. Once your spouse has been served, you need to wait at least 30 days from the date that you know that they were served before you can have your divorce hearing. And once that 30 days has passed, you can reach out to the clerk's office to request a court date. So usually you will need to fill out these 2 documents, a notice of hearing and a certificate of service. Most clerk's offices will have a blank notice of hearing form or a format that you can use for a certificate of service. So I recommend asking the clerk's office if they have a notice of hearing. Sometimes the form will say notice of hearing and calendar request. They'll kind of be those two things combined into one form, and you will need to file those documents. Any documents that you're filing before you have your hearing before the judge, you'll need to have 4 copies of them. And then, of course, once you file your notice of hearing and certificate of service, you'll need to, of course, mail a copy of those 2 documents to your spouse, just via regular snail mail, regular US mail at the last known address that you have for them. So some counties will only conduct divorce hearings on certain days of the month or certain times of the day. You need to make sure that you're giving your spouse enough advance notice prior to your divorce hearing. So the rule is that you need to give them at least 5 business days notice prior to the hearing, and that doesn't include weekends and court holidays. And then if you mail the paperwork to them, you have to also add 3 additional days. So I wouldn't just use the 8 days. There may be things that come up. I think it's always better to give a few extra days as cushion So what I generally tell people is, why don't you give them like 2 weeks notice, just to be extra sure that they've had have the necessary notice. You don't want to go to court and have a judge say, I'm sorry, but I don't think that your spouse has had enough notice to be here, and I don't really have any choice but to continue your case because we can't hear it today. That's a waste of your time. It's a waste of the court's time. So better to just build in some extra time if time is not of the essence. And most of the time, when you're seeking a simple divorce, you can afford to build in those extra days. So a testimonial divorce. These are the forms that you're going to need to bring to you on the day of the hearing. A judgment of absolute divorce, a certificate of absolute divorce or annulment, and then you'll want to bring a stamped envelope with you with your spouse's address on it. You'll need 4 copies of the judgment of absolute divorce and then 1 copy of the certificate of absolute divorce. We highly recommend that you fill those out on the computer and then bring copies with you to take to court. We have provided some sample forms in the packet on our website for you to take a look at. These are forms that you can ask the clerk's office. The judgment of absolute divorce, you can ask the clerk's office if they have a template that they can give you, and the certificate of absolute divorce you can download from the NC Court's website. So what does a divorce hearing look like? What happens at a divorce hearing? So remember, you'll bring at least 4 copies of the completed judgment of absolute divorce and the certificate of absolute divorce with you. Those are in your guide and file package. I always recommend to people, whenever you go to court, dress nicely, dress like you would if you were going to church, if you go to church. Some judges care a lot about that, some more than others. You don't want to give the judge a reason to send you home if you show up dressed, very sloppily, or send you out in the hallway to tuck your shirt in. So we always recommend folks, dress nicely when they go to court. Get there early so that you're there when the judge does a calendar call to see who all's present. Once you've figured out which courtroom you need to go to, you'll go in and have a seat. When your case is called, just let the judge know that you're present. And then when the judge is ready to hear your case, they'll call your case up. You'll approach the front. You'll stand at the table that the judge indicates for you to stand at. And the clerk will place you under oath. And then the judge will either have you testify there from the table where the attorneys sit, or the judge may ask you to walk up to the witness stand and have a seat. And then the judge will basically ask you the questions that are in the judgment of absolute divorce. It will track the information that's in the judgment of absolute divorce. So your name, whether you've lived in North Carolina, whether you or your spouse have lived in North Carolina for at least 6 months, if you've been lived separate and apart for at least 1 year before you filed, and the date that you got married, and so on and so forth. So it shouldn't take very long. These hearings usually don't take more than 10 or 15 minutes. Just be sure that you speak slowly and clearly and answer all the questions that the judge has for you. And then when you're testifying, you can have the judgment. If you have an extra copy, you can have the judgment of absolute divorce in front of you to refer to if you need to. Like we said, we provided a sample. This is a screenshot of one. We've already talked about a lot of this. You're going to bring 4 copies with you to court. If the judge grants your divorce, they will sign it there in court. The clerk will file stamp it. And then you're going to mail a copy of the judgment of absolute divorce on the date that you indicated on the certificate of service to your spouse, unless your spouse shows up for the hearing. If your spouse shows up for the hearing, then they'll get copies of everything and you don't need to worry about mailing it to them. But if they are not there, this is a required final step, is mailing a copy of the absolute divorce, judgment of absolute divorce, and the certificate of service to them. The certificate of absolute divorce or annulment, this is what this form looks like. This is the form that's required for vital records. And this is a sample has also been provided in your packet, but you can download this from the NC Courts website. So again, we talked about all of this. If the defendant's not there, make sure to mail them a copy of the certificate, the judgment of absolute divorce. And then keep a copy of the judgment for absolute divorce wherever you keep your important papers in a safe, secure location, because you may need it down the road. Especially if you have requested to resume your pre-marriage name. If you requested a name change, then you're going to want to get a couple copies, certified copies of the judgment of absolute divorce to take to the Social Security office and to the DMV to get your records updated.